Hello, everyone. My name is Jen Lee, and thank you if you're here live. I know it is hard sometimes picking a time zone to do some of these webinars and trainings in. So thank you for being here if you're live. It is being recorded. It will be posted for anyone who wants to see it later, or if you want to review it, that's fine. And if you have questions, you can use chat directly to me. You can use Q&A as well. There is an anonymous option. Our bankruptcy clients often don't want people to know that they're talking to a bankruptcy attorney. And so I also know that it's valuable to be able to ask questions without worrying about who knows you're asking them. And so I never say someone's name when I read the question or answer it. So feel free to ask questions. If you are watching the replay on this, feel free to email me, jen@lawyersuccessnetwork.com, or put a comment, whatever channel you're watching, and I will keep an eye on it. So reach out. Total bankruptcy nerd, would love to talk. We are going to jump into all the questions that I get about adding. So about once a year, I round up all the questions that I've got about adding bankruptcy as a practice area and throw them all into a nice webinar. Who am I? First of all, I am a complete and total bankruptcy nerd. I had a bankruptcy law firm in California and grew it to several attorneys. During COVID, I moved back home to North Dakota. So that's why I'm Central Time now. I live in North Dakota, and I've transitioned fully to helping lawyers add bankruptcy as a practice area, improve their bankruptcy processes. I also work with non-bankruptcy lawyers on just getting away from traditional legal models, access to justice, and that kind of thing. So I am living my best life on the prairie, helping lawyers figure out how to have really cool law firms. And so I always joke, I've been there, built that. You don't have to guess, Google, or wing it. And a little bit of background on how I got to teaching this. Back in 2020, when COVID hit, I was getting a lot of calls from lawyers who didn't practice bankruptcy, who wanted to add bankruptcy as a practice area, because everybody thought bankruptcy would be booming with what was going on with shutdowns in the economy. And so I rolled up a course, basically 12 modules that from beginning to end, how to add bankruptcy to a practice. It's not the only course you'll ever need, but it helps you get started from like the very basics to bankruptcy law, to marketing and that kind of thing. So when that course launched, I learned I really love teaching bankruptcy, and I really love helping clients, my law firm clients, with their first few cases and going through things in training. And so I have transitioned into doing that all the time now. And so that's why I'm the ultimate bankruptcy nerd. Now, as we know, bankruptcies didn't take off in 2020. All the stimulus money, the EIDLs, all the things out there delayed that. But we are seeing a huge demand for bankruptcy services these days, which is one of the questions we're going to get to. So like I said, if you have questions, jump in. I have some cool things to throw at you as we go through this. The first question I always get, especially from lawyers who don't do bankruptcy, and I do see in the attendees, we do have a couple of really experienced bankruptcy attorneys on here. So I'm hoping maybe that you'll all see something that's interesting. Aren't bankruptcy clients broke? How do you make any money doing this? I always tell people that bankruptcy clients aren't broke. They have a resource allocation problem. It's your job as the lawyer to help them adequately apply their resources to the things they need. So a lot of times it ends up being that they're not making minimum payments on credit cards, and you help them figure out how to pay their attorney's fees. So, and there are bankruptcy clients that are completely broke. I've worked with legal aid organizations. I've worked with some pro bono projects. There are clients who qualify for that, but I would say a lot of the clients that came through my law firm and the law firms I'm working with now, they're not broke. And the more you talk about financial stress in bankruptcy, the more proactive clients you will get, which is ultimately what you want. So how do the fees work in bankruptcy? Bankruptcy fees are generally flat fees, excluding Chapter 11. We're mostly going to talk about Chapter 7 and Chapter 13 today. I am a Chapter 13 nerd. I love Chapter 13. I think it's one of the best things in sliced bread. Normally they're flat fees though. And so in Chapter 7, the client pays a flat fee to the firm, And that is determined by your business model, by what you decide to do. There's no set fee for a Chapter 7 that people charge. Some districts you'll want to look at to see if there is a local rule involved that maybe caps the fees for a Chapter 7. I have seen a couple districts that have that. So you got to pay attention to your local rules. But generally for Chapter 7, you're looking at how much value you're putting into the case and how much time. I would say most fees are going to range from $1,000 up to $10,000, which is a pretty big range for Chapter 7. And it's going to depend on the complexity of the case. If you are a high volume filer, your fees may be lower. If you are a lower volume, the fees may be a bit higher. So it depends on the practice that you have and how you work your numbers to be profitable. I highly recommend when you're looking at setting fees and you're looking at how the clientele that you want for bankruptcy work, that you look to see what makes your firm profitable and how many cases you need. So I do a lot of cash flow forecasting with bankruptcy firms to look at the number of cases that are needed, what their closing rate is on things, and how to make it profitable. Because if you're not billing by the hour, which I'm very anti-billing by the hour, just to be very clear, you need to have ways to measure the cost that goes into your cases. So bankruptcy can be very profitable. You will find, I will try not to rant here too much. You will find that sometimes in the bankruptcy world, bankruptcy attorneys themselves often resemble their clients in the fact that they say you can't make money doing bankruptcy. And I very much disagree. I supported 5 attorneys at my firm with just the business I brought in. And I believe there's other firms out there doing similar things. You have to be intentional about it. And you have to be able to tell clients how they can pay you and what the outcome looks like. So some of it's marketing. So bankruptcy clients are not broke. And yes, you can make money if you set it up right. Keeping along the money lines, I did try to group these together because the questions I had that came in often fall into the same bucket. So I did try to keep them pretty close together. Startup costs. Startup costs can be fairly low. Most of the time, you need to have like the typical subscriptions that a law firm would have for Office or Microsoft or whatever you're using for word processing. All of those same things apply to a bankruptcy firm. I'm a huge fan of keeping overhead as low as possible. The great thing that came out of COVID, I will say, is that it made remote work more acceptable, even if you live in the district. My firm had been remote since 2010. And so it was not a change for me because we didn't have offices. However, the United States trustee and the 341 meetings that are done in bankruptcy. So when a case is filed, there is a meeting that takes place with the trustee about 30 days after filing. I think the code says 21 to 45 days. And that meeting used to be in person. They were hardly ever done by Zoom. Sometimes they were done by like written interrogatories if there was a really special case. But now what has happened is almost every 341 is on Zoom. And that has been great for purposes of keeping overhead low for attorneys and also our clients. They're struggling. And if you realize how much they're struggling, having to drive to a 341 meeting, which in some areas could be 1 to 2 hours of driving there and back, and they have a job. That has been a really great benefit of COVID is the Zoom meeting has become way more acceptable. It also makes it easier for lawyers than to have meetings with clients by Zoom or by Teams or whatever software you want to use, or even phone calls. A lot of them do phone calls. So for startup costs, you're going to need the basic things that a law firm needs. You need your practice management software if you're using anything. You need your bankruptcy software, which we're going to talk about in a second. I had several questions that came in about that. And then you're going to need your technology, whatever you're using for your workflows. It can be pretty low. You could also do it as a solo. You can outsource some of the pieces of it. You can have virtual assistants. I have several virtual assistants I work with for different things. And so I highly recommend people keep startup costs as low as possible and build from there. Can I do this from the beach? That's the one I get every once in a while. Regina's Lawyers on the Beach group. We got lots of lawyers that like to try to do these things from the beach. Yes and no. So yes, you can do a lot of this from the beach. There are some districts that are requiring in-person appearances, not necessarily for the 341 meetings, which are in every case, but there are districts that are requiring in-person for confirmation hearings in Chapter 13. So you really want to check your local practices on what's required for in-person. Bankruptcy, while it's federal, is very much a local practice. You'll want to know exactly what's happening in the district that you're practicing, because you don't want to get hometowned in an area where you're not expecting that. And one of the questions that just came in on chat: can an attorney work cases anywhere in the United States, regardless in which state the attorney bar is from? I have a great answer for that. It depends. Some states, so bankruptcy is federal. You have to be admitted at the district court, the federal district court in the state, wherever the bankruptcy court that you're filing in is. You have to be really careful with this. Some of those district courts require state court admission in that same state. Some of those district courts require you just to be admitted in any state to get at the district court. And then on top of that, once you're admitted to the district court, some bankruptcy courts do have a local rule that says, even though you're admitted in district court, you still have to be admitted in the state court for those bankruptcy courts. So again, be very careful. Some examples, for example, I live in North Dakota, and North Dakota is one of the few states that allows California attorneys to move for admission based on 5 years of experience. I happened to grow up in North Dakota, and so I was able to waive into North Dakota without taking a bar exam. So I had North Dakota license. North Dakota District Court does not require you to be a North Dakota bar attorney. So anyone can file cases in North Dakota as long as you're admitted to district court. You don't have to be barred here. Texas is very similar. Texas, you do not have to be admitted to Texas state court, to the State Bar of Texas, to be admitted in federal court, but each of the districts have different rules on who can be there. So the answer is yes and no. Check where you're filing at and what the state requires. There is probably some of the local protectionism goes on sometimes, where that's why additional rules apply, because they don't want attorneys that are filing cases that don't know the local rules, don't know the local market. So there probably is some protectionism there. But I will say, with as virtual and as the world has gotten, there are ways to be a good lawyer and not live in that specific district that you're filing in. In California, I filed in 3 districts. I lived in the Northern District. California's a big state. So good question, though. It's one of those ones where it's trying to figure out exactly where you can practice and what you can practice with. Check your federal court local rules. So you have your district courts. Let's see, let's jump on. But the beach is fun. Okay, so what does the bankruptcy market look like for demand? That was one of the questions. And then how do you get clients was the second one that kind of related to this one. So what does the bankruptcy market look like for demand? Bankruptcy has been increasing over the past couple of years. I will say, if you watch economic indicators, and again, I'm a total nerd, so that I have a lot of fun with this. Leading up to COVID in 2020, the first quarter of 2020 was my best year ever, best quarter ever for bankruptcy. It was already trending up 2018, 2019. And I was seeing a lot of small businesses. I do a lot of sole proprietor Chapter 13s with a lot of issues. And so leading up into 2020, we were already heading up with bankruptcies. They had been way down in 2014, 15 as we recovered from the last recession. And then they dropped way off. If you look at the numbers from 2020, 2021, 2022, bankruptcy dropped dramatically because of all the things going on with COVID. What we're seeing now is steady double-digit increases month over month, year over year. Every month, around the third, fourth, or fifth of the month, depending on how the weekdays land, I do a live stream that goes through the bankruptcy numbers for the previous month, year over year. I call it Bankruptcy Nerd Alert, and I'll put the link for that in chat, so that if you want to see what the market has been doing, there are some months where like subchapter fives are up 50% and it looks crazy. My cautionary tale on when you look at the demand is know what the numbers mean, because you can have a huge increase, but it was really due to like maybe a bunch of cases got filed under one brand or one corporation type thing. So have to be a little careful about that. But I am seeing a lot of demand. Most of the bankruptcy attorneys I know right now who are already practicing are booked out for consults several weeks. Just because there is that demand out there and it's hard to keep up with bankruptcy. The other question here, how do you get clients, relates back to what does the bankruptcy market look like for demand? Because I do have some people who say, well, I've added bankruptcy, but it doesn't seem to be taking off for my firm, or I don't understand how to get clients, or maybe there's a really big firm in my district that files a lot of cases. So my first answer to that is you don't want to compete with that big firm filing a bunch of cases. Chances are the big firm filing lots of cases has, they probably have lower fees. They have a system set up. It's all automated. Those aren't usually the clients that are going to go look for a solo or boutique firm. So you need to speak to the clients that you want. How do you get clients? So no one goes around telling people they need bankruptcy. That's not something that's done. Most of my firm was built up on referrals for networking, and I did a lot of speaking. I did a lot of educating of networking partners. I did a lot of videos. I did a lot of just talking people through financial stress. I never actually used the B word, bankruptcy, in any of my marketing, because people don't know when they need a bankruptcy attorney, but they know when they're financially stressed. So getting clients, you need to have a really clear website that you help people with debt and credit problems and bankruptcy if you want to use the B word. You need to have an easy way for them to reach out to you. And you need to have something set up so that you don't make it hard for them. Online schedulers are great for this because bankruptcy clients, like the best thing you could do if you're going to add bankruptcy as a practice area is understand the psychology of the person who is contemplating bankruptcy. They're scared, overwhelmed. They're making poor decisions a lot of times because they are scared and overwhelmed. And that often looks like falling for scams. And so you want to make it as easy as possible for them to schedule with you and to get good advice. And so the more you do that, the more clients start coming in. I still get referrals from people I met 10, 15 years ago that I now send to my former partners in California, because they just remembered all the talks I did and all the things I did. So getting clients, you don't have to spend hundreds of thousands of dollars on Google AdWords. You don't have to do a ton of like crazy marketing expenses. I didn't ever spend anything on marketing. It was more so getting the right information out there and being a resource in your communities. And then people want to talk to you. Getting into the software, I'm checking for questions again real quick. And I don't see anything good. Do I need bankruptcy petition software? Yes. Normally I say it depends. But when it comes to bankruptcy software, my answer is yes, you need bankruptcy petition software. So bankruptcy schedules are like 60 to 80 pages long, and they're PDF that you can download from the United States Trustees website. But going through and filling them out one by one is not my idea of fun. Bankruptcy petition software makes that so much easier to do, and it's fairly inexpensive compared to like an overall overhead cost. The other question I get is, what software do you recommend? I don't get paid by anybody to recommend software. The big ones out there these days are, best case is the OG. Best case is owned by Stretto. They're the ones that were the original, at least as far as I know, bankruptcy software. I got rid of best case. That's what I started with. I got rid of it in 2012 because it was very clunky. I didn't like it. And I like the cloud and I like my Macs. And they're not on Macs, and they kept promising to go to the cloud. Other ones out there these days, Next Chapter is an option. Next Chapter is a cloud-based, so you can do Mac or PC with it. They do have a really good client portal. They do have credit report integrations, and they also have templates that you can design out and things like that. So Next Chapter is also a good option. Jubilee is another one that used to be Bankruptcy Pro, a BK Pro, and Jubilee is a cloud-based, so you can use that on Mac or PC. Best Case does have a cloud-based version now, just FYI. And most of the softwares are going to run, depending on the plan you get, I've seen as low as like $600 a year for low filers up to $5,000 a year for higher end filers. So it just depends on the software and how many cases you're going to file. Find one that works for you. When I teach my course for adding bankruptcy, we do a whole module on demos of the different bankruptcy softwares, because all the firms I work with all of the different softwares. They all have pros and cons to them. The other one that sometimes gets mentioned is called Blue Stylus. Some trustees use it as a document portal, but they also have a petition prep software in there too. And again, pretty affordable. So those are all things to consider. I don't highly recommend any one of them above the others. It just depends on what your firm needs and how many users you have, whether you're Mac or PC, and then also how you want your schedules to look. Because one thing you'll learn about bankruptcy attorneys is a lot of us are very particular in how our schedules look and what we want the trustee to see about things and how we annotate things. So that is bankruptcy petition. Resources. Everyone asks, like, what are the resources out there to help? I'm going to put a bunch of things into chat here, and it may take off my sharing screen. I'm not sure what it'll do. You know, there's some days. The National Association of Consumer Bankruptcy Attorneys, NACBA, is it's the only debtors organization in the country that advocates for the debtor side of things. And so let me hit everyone here. So NACBA is a really great one to check out. So that it's NACBA.org, NACBA.org, if you're listening and not clicking on things in chat. So NACBA is a really good option they have CLEs, they have good conferences, very good advocacy. They will help with different state exemptions and things like that. So NACBA is a good organization to take a look at. Another organization that I like for daily news and alerts is ABI, which is the American Bankruptcy Institute. That one is going in chat too. So ABI is a little bit more on the creditor side, a little bit more corporate, bigger firms, but the information they have in their conferences are also really good. NACTT, National Association of Chapter 13 Trustees, has a website called considerchapter13.org. They are the academy, has a lot of articles and a lot of information that is useful. I write articles about 4 times a year for the academy. And then NACTT itself is the National Association of Chapter 13 Trustees. They do an annual conference in July. It's coming up, I think, in 2 weeks in New York City. So again, good conferences, good information, good materials. Things that I offer, I'm going to link this now. The Bankruptcy Nerd Alert. There's the playlist on YouTube on my Rebel Esquire YouTube channel. That has every month, I go through all of the filings, the numbers and what things look like, and I add things in every once in a while. Let me go back to my spreadsheet here. Let me see. Q&A. NACBA has a mentorship program. Thank you. Yes, NACBA has a mentorship program. They've come up with a whole bunch of new things recently in past couple of years. And again, their conference coming up this year, the members only workshop is in Hawaii. It's in Maui in October. And that one I'm hoping to be there and be a sponsor for. Their conference next year in April. If anyone from NACBA is here knows where the conference is next year in April, I don't remember. I think it's early April, but I don't know if I know the exact location yet. really good mentorship, CLE tools. There's a great listserv, all kinds of things that happen in NACPA. Um, Things that I offer. I know this is a lot of stuff. So I do have an online workshop called Building a Bankruptcy Practice from Start to Finish. And it is all 12 modules on here where we go through all the steps, the software, the logistics, the bankruptcy client process, which is a lot of the psychology, your initial consult, charging for consults or not charging is a whole discussion in there. And then modules 7 and 8 actually are 4 modules. There's 2 parts to each one where we go through all the basics of chapter 7 and 13. Fee agreements, marketing, cases that every bankruptcy attorney should know, and then war stories. I learned a lot by listening to other hearings and watching. And so I have my war stories there. I've also added on over the years, we have one called Survivor Means Test Island, where we go step by step through the means test that's included. And there are a few other things in there. My other resource I have these days is called Bankruptcy Toolbox. And Bankruptcy Toolbox is a monthly membership that has, there's channels in there for discussions. The channels are up there on the screen right now. We also do once a month a hypo hour where anyone can ask questions, any weird cases you have, that kind of thing. And then we have the Bankruptcy Business Lab, which is really fun. And I'm actually going to share that real quick because it just is so much fun. So the Bankruptcy Business Lab was my attempt at helping attorneys with the business side of things. And so this is the inside of Bankruptcy Toolbox. This is what you'll see if you log into Bankruptcy Toolbox. And these are the courses that are in there. There's a bankruptcy FAQ content, bank templates and forms. But Bankruptcy Business Lab is a monthly theme. So we have a theme every month on the business side of bankruptcy. And so last year we did the power of paid consultations for our first one because I'm a huge fan of paid consults, breaking fee from low fees. And all of these are recorded out there. So even though you weren't in last year, you get access to all the recordings. And then we just started the second round, the second year of the Bankruptcy Business Lab. And that schedule is out there as well in Bankruptcy Business Lab too. So those things are my way of being totally nerdy and sharing like all the things. I do daily bankruptcy news for articles and marketing. I just have a lot of fun sharing information about bankruptcy and trying to help firms be really profitable. So that's my nerding out on like resources that I have available. Thank you in Q&A says Orlando. I think I actually maybe did know that because I'm thinking my kids will be thrilled to hear that Orlando is the NACPA conference in April 2027. So thank you for that. So those are resources that are out there. There are others too. I am not a huge like get thousands of credits of CLE. I'm very practical with what I look at. So next question. And I do have a few more questions here. I just wanted to throw in resources in the middle here so that you all could see it. Does bankruptcy go well with, and then I get all kinds of other questions about various practice areas. And so I get estate planning, tax, family law. I will tell you the most common dual practice that I'm seeing right now is immigration attorneys and bankruptcy. I have about 6 right now where we're adding bankruptcy to their firms. They're doing immigration. And I know that's a hard practice area right now, but I also think it lends itself well to being a federal practice and somewhat remote at times. And so I do think there's a lot of crossover. With estate planning, tax, and family law, it does go very well with those practice areas because all of those cross over into bankruptcy on a regular basis. So yes, bankruptcy does go well with other practice areas. The other thing that makes bankruptcy a good either second practice area or more, it's counter-cyclical. So when the economy is getting worse, not that I want the economy to get bad, I don't want that to happen. When the economy is getting worse, other practice areas tend to get slower. Bankruptcy tends to pick up. So it can be a good cash flow sustainability model. We've done a lot of that, especially with tax and family law firms, to try to create like a stable cash flow basis for a firm using bankruptcy. How much do you spend each month on advertising? I didn't spend any money each month on advertising. So there's a couple of different models out there. And in one of the first modules that I have on my course, we do go through cash flow forecasting and how to look at that. The two different types of firms out there tend to be lower volume with a little bit higher pricing, or high volume with a little bit lower pricing. If you want to do the high volume bankruptcy, you need to have a lot more leads coming in and a lot more people calling in. And so that tends to be the type of firm that needs to have a lot of advertising, where you're paying for Google AdWords or SEO, or now, all of the AI searches, because AI is now recommending law firms. So it depends on the type of firm you have. I have tried in the past lead generation companies. There are several out there. I'm not going to name them specifically, but lead gen companies that they sell you, $50 a lead or things like that. Personally, for my business model, I found that those were not helpful. They weren't the types of clients that I wanted, and they were often selling the same name and number to multiple attorneys in the area, or multiple attorneys, maybe not in the exact same area, but in a geographical range. So I didn't find that chasing those types of leads was good for my firm. However, I do know firms that do pay for those types of leads. So it comes down to doing an analysis with the types of leads you want to come in, the price you're charging for services, and how many cases you need in order to make it profitable for your firm. So there is math involved. I'm sorry, if you're a lawyer who doesn't like math, bankruptcy may not be the best way to look at it, because the good bankruptcy attorneys, I feel, are pretty good with numbers. We do a lot of spot checking, a lot of checking to see if plan payments work, a lot of like, ooh, that doesn't make sense. You say on your questionnaire that you spend $500 a month on food, but that's not what I'm seeing on your, like, being able to do some quick math is kind of important. So I'm not, again, depends on your business model. Question came in: how are you utilizing AI in bankruptcy practice? And does it have a potential to assist you with the busy work? Yes, it does. AI is very helpful. And when I say AI, that's a huge range of things that could be. I have an app that does my Chapter 13 plans for me that I created in Claude. You can use ChatGPT. So at the NACPA conference a couple of years ago, I did an example of how to pull all of the last 6 months of income off of pay stubs. Now, cautionary tale, do not put client information, personally identifiable information, into a basic version of AI that has training all turned on. I'm not going to do all of the disclaimers on that. Be careful with it. But if you have a paid version with and you've redacted, that's often what I do. Is pay stubs are a great way to do that. It can analyze bank statements. NACPA had a really good workshop a couple of weeks ago on using AI to automate practices. I have trainings in Bankruptcy Toolbox on Claude, how to use it to process your emails. We do a lot of automations for responding to regular client requests, because your clients tend to freak out a lot. So there is a ton of opportunity for using AI. And it also keeps your clients happier when you are anticipating their problems and their questions, and you can use AI to do that. So that's a really good question. Thank you for asking that. Yes, all kinds of fun. Here's a question I get every once in a while. And for consumer side debtor attorneys, usually Chapter 7 and Chapter 13 are the ones that most of us do. Some of us do the Chapter 5, Chapter 11s, or individual Chapter 11s, but there tends to be a break. A lot of attorneys will say, I only want to do Chapter 7s. They're shorter. There's not like a 3 to 5 year time commitment on them. They appear easier. My answer is yes, but yes, you can do just Chapter 7s if you want to just do Chapter 7s. And some people are getting close to retirement. That makes sense too. You don't want to take on a 5 year case if you're going to retire in the next couple of years. However, I would encourage you to know when a client is a better fit for Chapter 13 and have a good source to send them to, because you're not doing your clients any favors by trying to cram them into a 7 when they really should be at least given the option of a 13. And oftentimes you will see people saying, oh, I only want to do it, like clients, debtors, I only want to do a Chapter 7 because I've heard that that's the easiest way to go. And then if you explain to them the benefits of Chapter 13, they're like, oh, I probably should consider that. So yes, you can do only Chapter 7s. Chapter 7s are slightly riskier than Chapter 13s because once a Chapter 7 is filed, you can't dismiss it. So what happens is sometimes people file Chapter 7 and they didn't disclose an asset, or the trustee finds an asset and is now going to sell that asset. And people are like, never mind, I want to get out of Chapter 7. That does not happen absent a really good reason. And so Chapter 7s are a bit riskier from that standpoint. If there are risky assets, Chapter 13 tends to be a safer route because you can dismiss a Chapter 13 absent some type of really bad faith behavior. So my answer is to this is yes, but you can do only Chapter 7s. Know about Chapter 13s and when a client should at least get a Chapter 13 consult and have some place to send those. I often was the person people sent their Chapter 13s to because I love them so much. So I do have some testimonials. I do like hearing from, I really love passing on the love of bankruptcy and being a total nerd to others. And so it makes me happy when my people in my programs call me and say, thank you, really appreciate this. And so I try to put my accolades out there every once in a while. So I really do love passing on the love for bankruptcy and doing it right. So I will say that there are a lot of models out there, and there have been the last 10 years or so, of people doing bankruptcy practice wrong. I did a webinar in early May, and it's out there in Bankruptcy Toolbox, called Scripts That Got Bankruptcy Lawyers Sanctioned. And it was some of these firms who are high pressure sales and trying to automate everything. And so non-attorney salespeople taking money over the phone and signing agreements. And so one of the reasons I like teaching this so much is because I want people to do bankruptcy right. I want the practice to excel. I want people to be taken care of from the client side. And that's a lot of the reason why I teach this. There are a lot of ways it can go sideways. And I've seen people give really bad advice. I've seen firms who don't answer their clients' phone calls or their emails, and it's not a good situation. Bankruptcy clients are overwhelmed. They don't make great decisions, and they often fall for those types of sales tactics. So my dream is to create the next generation of bankruptcy nerds like me. I do a lot of work with law students these days. I do have a deal once a year for a deal. If you want to add bankruptcy and you want the course, I do have $200 off if you join by June 30th. The code is BK2026. I will put it in chat. I don't do like high pressured sales. I will say I do a ton of reviewing first cases. I never say no. I never say, no, I can't help you with anything, because I want it to be done well. So just putting that out there. There's a lot of mentoring involved, a lot of one-to-one discussions. And I do a live version of the workshop 2 or 3 times a year. If you've bought the course, you get access to any live version in the future as well. So another question from a newbie. Thank you, newbies, for being here. Can you explain who the trustees are and the role they play? Are they attorney positions? Good question. So bankruptcy trustees in Chapter 7 are appointed by the Department of Justice, and they don't have to be attorneys. Their job in a Chapter 7 is to look at the debtor's assets to see if anything can be liquidated for creditors. Most cases that are filed, like 95%, do not have a liquidation of assets because of exemptions. Again, getting into the weeds there. So that's the trustee's job in a Chapter 7, is to liquidate assets, pay creditors, that kind of thing. They do not have to be attorneys. One of my favorite trustees in Northern California is actually an accountant. He's a CPA. Um, but they can be. And a lot of times you'll see bankruptcy attorneys also as a trustee sometimes when the positions open up. Chapter 13 is called a standing trustee. In most states, there are two states that have bankruptcy administrators, and I always, instead of the United, I always forget which one's which. Chapter 13 trustees are in charge of collecting payments from the debtor because it's a repayment plan, it's a reorganization plan. And the Chapter 13 trustee reviews the plan, makes sure that it complies with the bankruptcy code, and then collects the payments each month. Chapter 13 trustee then turns around and makes payments to all the creditors based on the plan that the court approves. And so those, I believe they're usually attorneys. I'm trying to think if I know any Chapter 13 trustees that aren't attorneys because they are filing things in bankruptcy court. They often have staff attorneys. Some small districts do not have a staff attorney on the Chapter 13 office. Some areas have multiple Chapter 13 trustees, like big districts. Some, like North Dakota, has one Chapter 13 trustee because we don't have that many cases here. And so you get one, you often know which trustee you're going to get because there's only one. Chapter 7 trustees, there's usually a panel and you rotate through, attorneys rotate through which trustee gets assigned to their cases. So hopefully that answered that question. Any other questions on what happens with trustees, what the client workflow tends to look like is your client waits until Friday afternoon at like 4:00 in the afternoon to call your office because they promised their spouse that they would call the bankruptcy attorney by the end of the week. And they don't want to go home for the weekend, telling their spouse they didn't call the bankruptcy attorney. And so oftentimes our phones ring very wildly on Friday afternoons and clients are scared. And so the more you have a good manner of helping people feel at ease, the better you will be as a bankruptcy attorney. There are also cycles. I often like to bring this up when we're doing cash flow forecasting. There are cycles in the year where bankruptcy calls come in faster than others. The busiest day of the year, and I post this on LinkedIn every year, January 2nd is probably the busiest day of the year for bankruptcy attorney calls. And that's because everybody made New Year's resolutions to get out of debt and lose weight. And I always joke, I can help with one, but not the other. And so January 2nd tends to be a very, very busy time to get phone calls and set up consults. There were a couple of years where I could tell the economy was faltering a little bit because we would have consults scheduled. I would open up a day between Christmas and New Year's and it would fill up with 7 or 8 consults. And so that often is a kind of warning sign that your January is going to be very busy. Other cycles throughout the year that tend to get busy, tax refund season or tax interception season. So before April 15th, I often will see increase in volume because people either get their tax refunds and can afford their bankruptcy attorney, or their tax refund gets intercepted. Either they owe student loans or taxes, and they decide they really need to deal with this. So tax season tends to be a very busy time of the year. Summer right now, and one of the reasons why I often do this Q&A in the summer is because it tends to be slower. I would probably argue this year it hasn't slowed down, but summer tends to be a little bit slower from a bankruptcy new client standpoint because kids get out of school and people are doing that thing in the summer where they're trying to get all the things fit in, figure out childcare, all the things. As soon as kids go back to school in August, it picks up again. At the end of the year, between Thanksgiving and Christmas, it is usually fairly quiet. We do a lot of cash flow forecasting in December. Bankruptcy Business Lab, every year in December, we do cash flow forecasting for the next year because it tends to be a little bit slower between Thanksgiving and Christmas because people are out spending money, not necessarily worrying about the debt yet. So there are cycles, and I like to put education stuff out there during lulls so that you're ready when the higher volume starts coming in. I'm trying to think if there is anything else on the cycles of what you see. Another question I often get is bankruptcy filing 7 versus 13. Which one do you do more of? Chapter 7 is about 75% of the individual filings in the US, and Chapter 13 is about 25%. So most firms tend to have a very similar break of 7s and 13s. If your firm is known for doing Chapter 13s like mine was, I skewed the other way. I did 75% Chapter 13s and 25% 7s. So just an overall view is you'll likely have 3 times as many 7s as 13s. That also depends on what the economy is doing. Chapter 13 means that someone has income, regular monthly income, and that's a very broad definition of what constitutes regular monthly income. It doesn't have to be a W-2 job, but you have to have regular income to do that. And so when we start seeing unemployment go up, Chapter 13s then drop because they don't have that regular monthly income to do a Chapter 13. So again, being super nerdy and watching economies, the cycles of things, how people think will really help with understanding how you want your workflows to work, how you want your business to run, and then also how you can plan your cash flow. Being very nerdy. One of the Q&As, 7 versus 13 depends on your exemptions too. Yes. So when you started analyzing whether someone should do a Chapter 7 or 13, some states have really horrible exemptions when it comes to like how much equity someone can keep in their house. For example, is it Pennsylvania that doesn't have a homestead exemption at all? California in the Bay Area, $750,000 of equity I could keep safe in a Chapter 7. The trustee's not going to sell it. But in Pennsylvania, if someone has equity, then they don't want to do a Chapter 7. And so some states that have poor exemptions, you'll see a higher number of Chapter 13s in those states because assets don't get liquidated in a Chapter 13 like they do in a 7. And so that is one of the main reasons people look at Chapter 13 is because they don't want an asset to be sold. They don't have exemption to cover it, or other reasons. They have a mortgage, maybe that's in arrears, maybe it's in foreclosure. Chapter 13 is a good solution for that. Taxes, you can get rid of taxes in bankruptcy, which a lot of people don't understand. There is a fairly complicated analysis involved to figure it all out, but you can do it. Chapter 13 is often used to help reorganize taxes. Understanding all those debts is really key to knowing Chapter 7 or Chapter 13. And that's why teaching the basics is really fun. Question that came in, is bankruptcy practice motion heavy, requiring lots of legal research, keeping abreast of new case law and hearings? It's actually not. For the most part. I should probably qualify and say it depends, but so bankruptcy practice, the way cases work is, let's take a Chapter 7. You file a Chapter 7 case. It's about 70 pages that go in with the petition, the schedules, statement of financial affairs, that kind of thing. The only actual meeting that happens is with the trustee at the 341 meeting. It's not a hearing. The trustee isn't a judge. It's just a meeting with the trustee. For most, like 95% of cases, that is the only meeting that takes place in a Chapter 7. There are some routine motions that get filed, like a relief from stay. If a creditor, say a car loan, the client isn't paying the car loan and the creditor wants to repossess the car, they would file a motion for relief from stay to get approval from the court in order to repossess the car. Those types of things are routinely handled either off calendar or non-opposition filed if there's no reason to oppose it. And so there isn't a lot of legal research and writing for motions. In Chapter 13, it can get a little bit more. I will say keeping abreast of new case law isn't that hard in bankruptcy. It's a small world. The bankruptcy world is a very small world. And a lot of the cases that come out, we usually spread like wildfire if something new or interesting comes out. If you have an interest in bankruptcy, you'll keep up on case law. And then hearings. Most districts have like standard hearings that are remote. Some districts, if you're going to go to an evidentiary hearing, and the places you may see an evidentiary hearing are the valuation. Like, let's say they have a house and the creditor thinks it's worth more than what the debtor does. Sometimes that will go to an evidentiary hearing. Most judges like to do those in person. I can tell you, I think in the 15 years that I did chapter 3, I probably had 2 evidentiary hearings like that. So you can avoid that. For the most part, in bankruptcy, there is litigation. There is a subset called adversary proceedings. And these kinds of cases are a lawsuit in bankruptcy court. And they are usually for things like a creditor thinks their debt should not be discharged because fraud. So these are in section 523 of the bankruptcy code. There's these exceptions to discharge. So sometimes a creditor will file a lawsuit that the debtor defrauded them and they shouldn't get the debt discharged. A lot of bankruptcy attorneys don't actually handle the litigation. They refer those out to an attorney who does handle the litigation. You will often know that a case is going to be problematic and involve litigation before you even file it. If you've got a very contentious creditor who's causing problems and won't let anything go, you'll often know that before. So I know a lot of attorneys who don't do any litigation in bankruptcy. They have referrals for them. I know some attorneys like me who like the litigation side. I like the strategy side of it and trying to figure out good results for my clients. So no, it's not necessarily hearing heavy. Depends on your local court as far as chapter 13 confirmations. A lot of those are off calendar. And most cases don't involve an actual court hearing absent something a little bit different. So, but yes, I do end up hearing a lot of, like, I don't want to go to court. Is this a good practice area for me? It can be like, you can do like straightforward, simple chapter 7s. I had an attorney that was doing that in California, and then she got a case that she probably shouldn't have filed. There was a lot of red flags in it, and it turned into litigation, but then she referred the litigation out to someone who does the litigation side of it. So, and it's similar, I think, between business transactions. I know we have some business transaction attorneys here. We have a litigator on too. A lot of times in the business world, attorneys specialize like that too. One does the transactional and one does the litigation. And it's similar in bankruptcy world. Bankruptcy is under the federal rules of bankruptcy procedure, which mirrors the federal rules of civil procedure. So a lot of times the litigation is familiar to people who have litigated in federal court. Very similar rules. Other questions or other nerdy things I can answer? I know I've been talking for like 53 minutes. And thank you for the great questions. And thanks for those that sent them in too. I will say the marketing one probably came up the most, like how do you get clients? And that is, again, making it easy for people to know what you do, and oftentimes avoiding the B word altogether, because nobody wants to say they need a bankruptcy attorney. But if you ask them if they're financially stressed, 95% of the country will say they're financially stressed. So I do a lot of those, like creating presentations for lawyers I work with. I do a lot of like helping them come up with speaking engagement ideas. One of the trainings we did a couple of months ago was how to be a strategic speaker. I did a lot in California before COVID, a lot of speaking at Rotary clubs, Kiwanis clubs. And I wasn't talking about bankruptcy. What I was talking about was how financial stress affects their communities and their workplaces. And that was my in. And I would get a lot of referrals from people from those kinds of speaking engagements, because I wasn't going in and talking about bankruptcy itself. I did a video yesterday for some financial advisors on what financial professionals need to know about how bankruptcy works, because there's so much bad information out there. And I already had like 4 people reach out for referrals to bankruptcy attorneys in other parts of the country. So using content like that and creating it is fun for me. And I also enjoy passing that on to other attorneys too. So, but if you want to do Google AdWords, you can, just have to pay for it. Other questions? Otherwise, I will feel free to reach out to me if you have questions. My email address, I will put in chat real quick. I did send an email out yesterday. I don't know if ever, sometimes, things go to spam. feel free to reach out. Jen@lawyersuccessnetwork.com is my main email address. And if you have questions, I'm happy to like talk through what you're thinking about doing. If you're an immigration attorney, the thing to add these days is bankruptcy. So reach out. And then, like I said, I do have this once a year deal that I offer on the full course, which includes a bunch of add-ons too, including family law and bankruptcy issues. It includes bankruptcy from A to Z. It includes dischargeability issues. So there's stuff that I've added on to the modules over the years. So questions, let me know. But otherwise, thank you for letting me be a bankruptcy nerd for an hour and talk through such a great practice area because I love it. Very good. I don't see any more questions. No more Q&A. Unless I'm missing something, then someone should throw things at me. Okay. Thank you all.